Hi, everybody, and welcome to Juvenile Justice. We are going to begin with Chapter 1, and we are going to focus on the history of the juvenile justice system. So, prior to the 1900s, there was no separate system of justice for juveniles. Any juvenile that got into trouble or broke the law was handled the same as an adult in the same court and was given the same consequences and held in the same prisons as adults. There were even executions of children and throughout the history of the United States. It's rare. It was rare prior to the juvenile justice system introduction. But I do believe the youngest child ever was to be executed was about 7 years old. So at the time, people were saying, okay, this doesn't really make sense that we don't have two separate systems. Children are different than adults, right? But you have to remember the sociological context. So prior to the 1900s, you have to remember and understand that children were considered what we call chattel. And chattel means that they are property. They were the property of their parents, specifically their fathers. And remember, back at that time, women were the property of their fathers until they were married, at which point they became the property of their husbands. And because it was property, children and women were considered property. They could be handled in any way they saw fit. It was a private matter. That if you wanted to sell your children into slavery, you could do that. If you wanted to beat your children as punishment, that was your choice. It was a private matter. If you wanted to kill your children as a result of something they did, there was no legal prescription against that because it was a private matter. Children were considered private property. So there was the problem, though, at this time of children who were unwanted, children who were abandoned because their families couldn't afford them or didn't want them, or children who were orphaned and both parents were just gone and there was nobody to take care of them or look after them. And so society's response at the time was to develop a system of workhouses, of orphanages and training schools or apprenticeships where we deal with these unwanted abandoned children. They were put to work at very young ages with the thought process that if they're working, they're not, someone's watching them. There's a boss, there's people around, and they're not getting into trouble. They're not out breaking the law and causing trouble. But what ended up happening here is that this ended up turning into a system of organized servitude, right? This was during the Industrial Revolution when we saw a boom of manufacturing development. And what we saw were there was a lot of wayward youths that were working more than full time, right? 10, 12-hour days in terrible conditions. The Industrial Revolution was prior to the introduction of OSHA and government regulation of workplaces and workplace safety. So there was no such thing, as sort of anything goes in those workplaces, and it could be very dangerous. Not just, the exposure of random children to random adults, but also the machinery, the lack of safety protocol, et cetera, was very dangerous for young kids. A lot of that machinery in the Industrial Revolution was very complex in terms of having a lot of small spaces that adults couldn't fit into, and adult hands couldn't fit into the machines, but child hands could, and children could get in there and manipulate the way adults couldn't. So there was a lot of incentive to keep children working as a way to curb problems and delinquency. But at this time, we had a group of people who were reformers who objected to this practice of children working. And when I say children, we're talking kids as young as 5, 6, 7 years old who are working in factories. And they began to argue that the way to curb delinquency is not through work, but it's to remove children from poverty and to remove children from cities. And, this was a long time ago that these reformers came forth and they asserted this, but they're onto something because crime of all kinds, whether it's adult or juvenile, is driven by poverty in a big way. It's one of the biggest driving factors of crime. And more crime happens in cities than anywhere else because there's more poverty in cities than anywhere else. So the reformers were onto something. So houses of refuge were created, and they were first created in New York, and one of the earliest houses of refuge was created in the city of Philadelphia in Pennsylvania. And these houses took in abused children, kids who were neglected, kids who were delinquent, and it focused around providing them structure. There were people who were there to supervise them, teach them religious teachings, teach them the structure of a daily day, the value of hard work. They were there to, remove kids from their immoral parents and teach them how to be moral people, since their parents were arguably not doing that. And arguably, it was just there to teach them how to behave appropriately in society. It's with the introduction of these houses of refuge that we saw the development of parens patriae and in loco parentis, which are just two terms that mean specifically it's a legal concept that the state can step in and intervene on behalf of the child and act as the parent in the best interest of the child. And they can do that in instances where parents are not doing their job, or parents are absent, or parents are neglectful. And this is going to take us to our first case. We have a lot of case law here in juvenile justice. We're going to go through a lot from the start to the end of the term. And the first case we're going to start with is Ex parte Kraus, which happened in 1838. So there was a mother, she had a child, she had a daughter, and she petitioned the court and said, hey, I'm very poor. I don't have time to watch this child. I'm working, and the money that I make only supports me. I can't support her. I can't take care of her. So please take her to a house of refuge. Please intervene. And so they did. And, a period of time elapsed, and Krause's father came forth and said, wait a minute, I just found out that my daughter was put into a house of refuge. Nobody contacted me. Nobody asked me if this was okay. You can't take her out of my custody. And you certainly can't take her and put her in a house of refuge away from the rest of society, away from free society, when she didn't do anything wrong. She didn't break any laws. So it's not fair for you to put her there. And I want custody of my daughter back. However, the Pennsylvania State Supreme Court disagreed with Mr. Krause and ultimately ruled against him and said, look, houses of refuge are not meant as punishment. We are trying to act in the best interest of this child. And both you and your wife are not able to take care of her. You're not around to supervise her. So we are putting her somewhere where adults can supervise her. It's not a punishment. It's meant to help. It's meant to educate. To be a school and a place of supervision and safety where her needs are met. And this is the case that legitimized the ability of the state to step in and remove custody of a child from the parents. This is the first time this battle between parental rights versus the state acting in loco parentis ever happened. It also legitimized the use of refuge houses, and it also legitimized this standard of children as separate and distinct from adults in the eyes of the law. So around this time, we also saw the introduction of what we call the child saving movement. And the child saving movement was a group of women who argued to the legislature that there are many differences from childhood to adulthood, and therefore there should be a different set of justice for kids who get in trouble and break the law. That kids, lack experience, they're not done growing, they're impulsive, their cognitive development isn't complete. So why are we holding them to the same standards that we hold adult offenders? There should be a whole different set, and we should handle it in a completely different way. In addition, these women, the child saving movement said, hey, we also need to reform these labor laws, and there needs to be an age at which children cannot work and an age at which they can. And we enacted legislation to say, okay, below a certain age, children can't work. It's illegal. We shouldn't have 5, 6, and 7-year-olds going to the factories every day and putting themselves in harm's way. And finally, this child saving movement are the first to introduce restrictions and legislation against child abuse. It's kind of a really sad state of affairs, but the way this came about is that there was legislation on the books that you could not abuse animals. And the child saving movement came along and said, wait a minute. Okay, this guy over here can be arrested for beating his horse, but not his child. There's no laws on the books that protect children from being beaten, but we do have laws that protect dogs and cats and horses from being beaten. What is wrong with this picture? And this is where legislation against child abuse and neglect was formally introduced. Now, some argue that the child saving movement was completely moral. It was well intended. It did a lot. Either way, it did a lot for the protection of children and adolescents. But there is an alternative argument to that the child saving movement was targeted, and it had an alternative agenda, that they focused mainly on poor children and remove them from their poor environment to teach them how to behave, so that when they become of a certain age, they will be good workers and they will function according to society's standards. That debate's been raging for decades. I'll let you draw your own conclusions. But this child saving movement said, okay, we need a separate system and it needs to operate differently. The adult system looks to punish people who have committed crimes, who've been convicted of crimes. The child juvenile justice system, kids are seen as malleable, right? They're not yet set in their ways. They're growing. They're experiencing. We can guide them. We can shape them towards better behavior, law-abiding behavior. So let's approach them as a medical model. That when there's a child who is having a problem, some sort of problem, if they're breaking the law, we want to diagnose the problem, diagnose the issue. Why are you breaking the law? Why are you doing this? And once we diagnose the issue, then instead of punishing them and sending them to prison, we need to set up a system of treatment. We need to develop treatment. Okay, you're breaking the law because of A. So in order to get you to do that, to stop doing that, we're going to develop a system of treatment. So, for example, if somebody's breaking the law, if a child's breaking, they're stealing because they don't have food and they don't have clothes and their needs aren't being met. Well, we just diagnosed the problem. So, what's the treatment? We need to make sure that this child has access to proper food and clothing, right? Instead of throw them in the slammer. We don't want to do that. No, we want to fix the problem and teach this child, make sure their needs are met, teach this child that you don't steal. There are other alternatives that are legal, pro-social, and that's the treatment. Okay, and that's supposed to be the ideology and the approach of the juvenile justice system. First juvenile court was developed in Cook County, Illinois in 1899. Like any brand new system, it wasn't perfect. It had errors. There were a lot of bumps in the road that they had to fix. The early court system was criticized for, trying to force restraint, trying to force, control on the kids rather than the diagnose and treat perspective. It was, criticized for targeting only poor children. It was criticized because due process rights were lacking for the kids who came into the system. From 1900 to about 1960, we call this the due process model of the juvenile court. And during this time, there was a lot of case law, a lot of litigation that went through our court systems about the rights that juveniles should be extended once they enter the formal legal system. And it was this time period emphasized heavily making sure that not only are we diagnosing and treating the problem, but this is still a legal process. Adolescents and juveniles who come into the legal process have rights, and those rights need to be respected and protected. We are in the current system, which started at about 1980. The current system is the punitive model of juvenile justice. Now, I know I've told you it's not supposed to be punitive in nature. But what happened is around 1980s, there was a lot of pushback that the juvenile justice system was too gentle. It was too lenient with the offenders, and that their offending and their reoffending, their recidivism rates were not going down, and therefore our approach wasn't working, and we need to get more punitive in nature. And that's what has resulted in where we currently are. Specifically, there were 4 factors that resulted in this punitive era in which we still function. The first is going to be the perception of increase in violent crime. This is a misperception. The data doesn't support it, and we'll talk about that later. But there was this perception in the 80s and the 90s of these chronic criminal adolescents that coined the term super predators that really pushed for this punitive approach. There was an increase in focus on habitual juvenile offending. Okay, so there's a small number of juveniles that do a lot of offending. And the argument was, well, obviously our approach isn't working. There was an increase in juvenile gang development, not just in cities, but also in rural and suburban locations. And with that increase in gang development came an increase in gang drug use, adolescent drug use, and gang drug trafficking. And finally, there were arguments that the increase in due process rights for adolescent offenders was making it too difficult for us to put deterrence on their behavior.